So good morning. Welcome everyone to this first session of the International Dialogues in Constitutional Law in 2019. It's a big pleasure to have you here and a big honor and privilege to start off the year with the presence and the lecture of Professor Linda Greenhouse from Yale University. I don't think I have to say much about her trajectory, but I have really to emphasize that it's a big opportunity to discuss the intricacies of understanding the role of courts from a scholar that has a very unique profile. She basically covered the U.S. Supreme Court for almost 30 years, and the New York Times became really influential in the national coverage of the court and really set a standard of judicial journalism and combines that with scholarship. So I hope, Linda, you enjoy your experience here. Linda will talk for about 30, 40, 45 minutes about this topic, which is the interaction of civil society and the U.S. Supreme Court. And then we'll have a long time to debate as well. So without further ado, I'd like to thank also, of course, Virgílio. I'd like to introduce myself. My name is Conrado. I forgot to say that. So, Linda, the floor is yours. Thank you so much. And afterwards, of course, you can, it's always important to emphasize, you can raise questions in whatever language you feel comfortable. We can do our effort to translate that as well. Okay? So, Linda, please.
Thank you both for having me, for inviting me. I've had a very interesting time here in Sao Paulo. I enjoyed our seminar yesterday with the graduate students. So I'm going to talk about our Supreme Court, the U.S. Supreme Court. And as you know, our country is facing many problems right now. Problems that have some consonance with the problems that Brazil is facing. So that's the general context I'm going to talk about. What's become a very activist Supreme Court, activists on the right, and I'll talk about the implications and the impact of these recent developments. So I'd like to begin by setting two texts side by side and inviting you to compare them. We were going to put them up on the board, but you'll just have to listen. So my first text is a paragraph from an opinion by a long ago Supreme Court Justice, Justice Potter Stewart. In a case from 1977, the case was called Abood against Detroit Board of Education. It was decided by a vote of 9-0. It was a case about organized labor. And the question was whether the First Amendment's right of free speech and association, gave public employees who chose not to join the labor union the right to opt out of paying that portion of the union dues that provided the union with the resources to fulfill its duty to represent everybody in the bargaining unit. That's required under federal labor law, whether they're union members or not. In other words, at issue was the constitutionality of what was known as the agency fee system, under which nobody had to join the union, but everybody had to pay their fair share of the union dues that went to obtaining the benefits that everybody received. The objecting employees in this case, people who brought the case, argued that this system subjected them to an unconstitutional degree of what they called ideological conformity. So this is how Justice Stewart, writing for the court, analyzed the problem. It's a long paragraph, and I'll just quote it because it's important for the context. He said, To compel employees financially to support their collective bargaining representative has an impact upon their First Amendment interests. An employee may very well have ideological objections to a wide variety of activities undertaken by the union in its role as exclusive representative. His moral or religious views about the desirability of abortion may not square with the union's policy in negotiating a medical benefits plan. One individual might disagree with the union policy of negotiating limits on the right to strike, believing that to be the road to serfdom for the working class, while another might have economic or political objections to unionism itself. An employee might object to the union's wage policy because it violates guidelines designed to limit inflation, or might object to the union seeking a clause in the collective bargaining agreement proscribing racial discrimination. The examples could be multiplied. To be required to help finance the union as a collective bargaining agent might well be thought, therefore, to interfere in some way with an employee's freedom to associate for the advancement of ideas or to refrain from doing so as he sees fit. But such interference as exists is constitutionally justified by the legislative assessment of the important contribution of the union shop to the system of labor relations established by Congress. And here Justice Stewart quotes from an earlier opinion by a very famous justice, Justice William O. Douglas. Quote, "The furtherance of the common cause leaves some leeway for the leadership of the group. As long as they act to promote the cause which justified bringing the group together, the individual cannot withdraw his financial support merely because he disagrees with the group's strategy." That's the end of my quote from the opinion. The furtherance of a common cause. So hold that thought, and I'll turn to my second text, and I'll also give a bit of context for that. In January of this year, a federal district judge in Philadelphia granted an injunction barring enforcement of new rules issued by the Trump administration. That's the first time I'll use that word, not the last time. Exempting employers with religious or, quote, sincerely held moral objections to contraception, to birth control, from the requirement in the Affordable Care Act, which some of you may know as Obamacare, to provide birth control along with other preventive coverage in the employee's health plan. So Obamacare requires that if an employer has a health plan, they have to include all the services, including paying for birth control. This judge, Wendy Beetlestone, noted the, quote, remarkable breadth of these exemptions, which apply to for-profit businesses as well as non-profit businesses. She noted that Congress had considered, actually, and rejected a broad conscience opt-out from the birth control mandate when it voted for the Affordable Care Act. The new rules, she said, thus violated the plain command of the statutory text. And she observed that if enforced, the rules would cause thousands of women to lose insurance coverage to which they were legally entitled. And now to my text. The response of the press secretary of the U.S. Department of Health and Human Services to Judge Beetlestone's ruling. Quote, "No American should be forced to violate his or her own conscience in order to abide by the laws and regulations governing our health care," unquote, said Caitlin Oakley. The story I have to tell inhabits the space between Justice Stewart's invocation of our common cause and Miss Oakley's seeming obliviousness to the welfare of thousands of American women who happen to work for bosses who object to birth control. I argue that these two texts stand as goalposts at either end of a playing field known as civil society. If the two cases appear asymmetrical, if the two texts appear asymmetrical, one, a statement by the Supreme Court in a published opinion, the other, a remark by a federal bureaucrat in immediate response to breaking news, the asymmetry is likely to be only temporary. Judge Beetlestone's opinion, after an initial appeal, is highly likely to reach the Supreme Court, a court that only 3 years ago found itself unable, following the death of Justice Scalia, when it had a even number now, 8 instead of 9, to decide the permissible scope of an accommodation to employers unwilling to abide by the birth control mandate. That shorthanded court statement in a case called Zubik against Burwell provided the gap that the Trump administration's broad exemptions now seek to fill. With the addition of 2 new justices, Neil Gorsuch and Brett Kavanaugh, both appointed by President Trump, there's reason to expect that today's Supreme Court will be able to decide that question and to decide it in favor of the conscience opt-out. And what would be the harm of that? The United States, after all, has a proud tradition of protecting minorities who assert claims of conscience against mainstream norms that would overwhelm or even crush unconventional practices and belief systems. If the political system has often failed to extend such protections, the courts have done so. Such Supreme Court decisions as Sherbert against Verner, which protected a Seventh-day Adventist from having to work on his Sabbath, and Wisconsin against Yoder, which exempted the Amish from having to send their children to high school, and they believed that sending their children to high school would ruin them. These are well-known cases to anyone with a passing familiarity with the history of the First Amendment's free exercise clause. These decisions are celebrated as symbols of American society's commitment to freedom of conscience, of the protections of conscience as an essential part of civil society. The Civil Rights Act of 1964 protects religious claimants from employment discrimination and requires employers to accommodate the needs of religiously observant employees as long as the accommodation will not impose a, quote, undue hardship on the conduct of the employer's business. The conservative writer Ryan Anderson, in an argument against same-sex marriage, observed that, quote, religious liberty plays a crucial role in preserving civil society as something separate from government, unquote. Few of us would argue with that statement as an expression of abstract principle. But given recent developments in U.S. politics and law, we need urgently to move from the abstract to the concrete and to question whether conscience claims, as they are being expressed and honored today, rather than embodying the best of civil society, have become a threat to it. So with that introduction, I want to focus our attention on the Supreme Court and to begin on the most important decision of the Supreme Court's last term. That most important decision was not the failed challenge to the Trump Muslim ban. It was not the case on the rights of the Colorado baker who didn't want to bake a cake for a same-sex couple's wedding celebration. It was a labor case, a case called Janus against American Federation of State, County, and Municipal Employees. The question in Janus was whether to overrule our old friend, Detroit Board of Education against Abood. To the surprise of absolutely no one, that's what the court did. For reasons I will describe, that outcome, and even the vote, 5-4, had been expected for some years. The decision was highly anticipated by the time the case was decided last June 27th. It did not go unnoticed. But few people, I think, fully comprehended just how radical this decision was and how much it tells us about the current Supreme Court, the state of our constitutional law, and the emerging impact of the court's constitutional vision on American society. Janus is well worth examining from several angles: First Amendment doctrine, judicial behavior, practical impact. I'll discuss these in order to lay a foundation so that we can see the case as a whole before I get to the most important point, which is what the decision suggests about the Supreme Court's role in the fraying of civil society. I'll begin briefly with the First Amendment as doctrine. From today's perspective, the mediated view of the First Amendment that the court expressed 42 years ago in Abood, that the First Amendment provides a framework for balancing the collective interests of the state against the interests of private speakers, seems to come to us from a different era. It was an era when the First Amendment served to enable free and open public discourse. An era before, for example, the Supreme Court ruled in 2011 in a case called Sorrell that Vermont violated the First Amendment rights of pharmaceutical companies when it barred pharmacies from selling doctors' prescription records records that enabled pharmaceutical salespeople to make targeted sales pitches to doctors for expensive new drugs for patients who were being treated with expensive old ones. This was a law that the state of Vermont had enacted as a consumer protection law. The Supreme Court ruled that it violated the First Amendment rights of what we call big pharma, the companies. It was an era before the D.C. Circuit ruled that tobacco companies have a First Amendment right not to be required by federal law. Federal regulators implementing a 2009 Act of Congress to display on their packaging disturbing photographs of what happens to people who smoke, a decision the Obama administration decided would be counterproductive to appeal to the Supreme Court because the Supreme Court would probably just affirm. And just to be comparative for a minute, Australia, for instance, has a very vigorous anti-smoking law, and the pictures they require on the cigarette packaging, you look at those pictures of people, what happens to them, and you would never pick up another cigarette, but that can't happen in the United States because of the First Amendment. Early this year, the U.S. Court of Appeals for the Ninth Circuit, relying on the Supreme Court's most recent First Amendment precedents, granted a preliminary injunction against enforcement of San Francisco's, what San Francisco called the sugar-sweetened beverage warning ordinance, which requires soda advertisements to contain a warning that drinking beverages with added sugar contributes to obesity, diabetes, and tooth decay. Those are true statements, right? The required warning also had to include the notice that this is a message from the city and county of San Francisco. That was viewed as compelled speech. There's little doubt that a few years ago, this public health measure requiring the inclusion of truthful information in a commercial advertisement would have been upheld. The Ninth Circuit's conclusion to the contrary was unanimous. In other words, Abood was the product of an era before the First Amendment was turned into a potent tool of deregulation. Before it was, in the words of Justice Elena Kagan's dissenting opinion in Janus, weaponized. So when Justice Alito, writing for the majority in Janus, said that Abood had become, quote, an anomaly in our First Amendment jurisprudence, it was hard to argue with him. The shorthand for what Justice Stewart offered as a rationale for Abood became known as the free rider problem, the notion that peace in the workplace was threatened by the presence of fellow workers, free riders, who were not paying their fair share. It's worth noting that a series of decisions following Abood made it clear that the fair share obligation extended only to the expense of collective bargaining. Employees could opt out of paying for expenses connected to a union's political advocacy, and few questioned that distinction as a matter of law or policy. But the Janus majority found any such distinction unworkable as a means of solving what it viewed as the central problem, coerced speech. As Justice Alito explained, quote, petitioner strenuously objects to this free rider label. He argues that he's not a free rider on a bus headed for a destination he wishes to reach, but is more like a person shanghaied for an unwanted voyage, unquote. The impact of Janus is considerable, extending well beyond the labor context. For example, the court's analysis has invited litigation against mandatory bar dues, bar membership for lawyers. The justice actually considered one such appeal this term, a challenge to the mandatory bar membership in one state, the state of North Dakota. That case was filed before Janus, clearly in expectation of Janus's outcome. The justices took the case up in their private conference 8 times during the fall, before finally vacating the Eighth Circuit decision, which had upheld the compulsory bar membership, and the court remanded the case to the appeals court for reconsideration in light of Janus. While the court's docket-setting function is notably opaque, the court almost never explains why it's taking a case, why it's not taking a case. It's clear from the many times that the justices are listed as having discussed this petition at their weekly conference that the disposition was controversial inside the court. It's highly likely that some members of the court were eager to take up the bar dues case immediately without waiting for the lower courts to decide how to apply Janus in related challenges. There will be other such cases in the pipeline in short order. And of course, Janus will exact a substantial price from public employee unions, which under the legal duty of what's called fair representation will have to continue doing their work on behalf of non-members and members alike, even as their dues revenue shrinks. It's no coincidence that public employee unions have been a target of political and judicial conservatives, even as union membership in the private sector has shrunk almost to invisibility, standing now at only 10% of all private employees. Union membership is actually quite robust in the public sector, where more than 1/3 of employees are union members. Further, public sector unions tend to skew progressive. They support Democrats. In the wake of Janus, there are lawsuits seeking to claw back agency fees that have already been paid. One such case was recently dismissed in federal district court in Seattle. The judge declared that the union was entitled to a good faith defense because the dues were constitutional at the time the union collected them, but there are other such cases pending, and they may soon find friendlier judicial audiences. What does Janus tell us about the Roberts Court? I think we can conclude without exaggeration that it tells us that no precedent is safe. Janus provides a roadmap for how to hollow out a precedent so completely that a baby's breath can deliver the final blow. And I can't emphasize enough the extent to which overturning Abood was Samuel Alito's project, and here in brief is how he did it. The story, I think, is quite illuminating about the relationship of a single Supreme Court justice to the country at large. It began in 2012 with a case called Knox against Service Employees International Union. The question was a very narrow one: how the union should have treated a special dues assessment and what accommodation it should have offered to objecting members of the bargaining unit. But Justice Alito, in a decision signed by 5 justices, went beyond the question presented to place Abood squarely in the court's sights. He said, quote, "Our prior decisions approach if they do not cross the limit of what the First Amendment can tolerate." He said in any future case, quote, "The general rule that individuals should not be compelled to subsidize private groups or private speech should prevail." This was, of course, an invitation to bring the court more cases. The next one arrived 2 years later, a case called Harris against Quinn, and that produced another 5-4 decision with a majority opinion by Justice Alito. It held that Abood should not apply in the context of unionized home health workers due to an employer-employee relationship that's quite different from the relationship in a conventional workplace. But then Justice Alito went further than necessary to decide that question. He said Abood was questionable from the start. The court in Abood, quote, "failed to appreciate the conceptual difficulty," he said, "of the fact that in the public sector, both collective bargaining and political advocacy are lobbying directed at the government." Quinn had been brought to the court by an organization called the National Right to Work Legal Defense Fund, which in its briefing asked the court directly to overturn Abood. That was not necessary, Justice Alito said, not necessary yet. Justice Kagan, in an opinion for the 4 dissenters, saw what lay ahead. There was no principal distinction between this case and Abood, she said, and therefore no need for the majority's extended discussion of Abood's supposed deficiencies. Quote, "Today's opinion takes the tack of throwing everything against the wall in the hope that something might stick," Justice Kagan said. It would stick soon enough. The following year, 2015, Friedrichs against California Teachers Association reached the Supreme Court. This was the first case since Justice Alito began his campaign that squarely presented the issue in a posture that gave the court a clear choice between reaffirming Abood or overturning it. The litigation was financed by the conservative Lindy and Harry Bradley Foundation through its grantee, the Center for Individual Rights. Bradley also financed, at least in part, 11 of the organizations that filed amicus briefs on the plaintiff's behalf at the Supreme Court. Friedrichs followed a very unusual path to the Supreme Court. In federal district court, the plaintiffs did not contest the union's motion for summary judgment. Then, having lost in district court, according to plan, the plaintiffs asked the Ninth Circuit, that's the appeals court, to affirm their defeat. They went into court, they said, "Please rule against us as quickly as possible." Obliging, as settled law required, the appeals court affirmed in a 1-paragraph order calling the case, quote, so insubstantial as not to require further argument. Despite the absence of a conflict in the circuits, which is the usual marker for a court that's deemed worthy of Supreme Court review, the Supreme Court agreed to hear the case. Argument took place in January 2016. By the end of the argument, it was perfectly clear that Abood would be overturned by a vote of 5-4. Justice Alito, we can assume, received the assignment from Chief Justice Roberts. He no doubt turned quickly to the welcome task of drafting his majority opinion, finally achieving what he had set out so deliberately to accomplish. Then, the next month, shockingly, Justice Scalia died. There would be no majority opinion because Justice Scalia certainly would have been one of the 5. Not this time. By a 4-4 vote, the justices affirmed the Ninth Circuit in a one-line order. Without further discussion or explanation, I should say that a tie vote in the Supreme Court automatically affirms the lower court opinion, but it doesn't set a precedent. It's as if the case never got to the Supreme Court in the first place. Justice Alito would have to wait just a bit longer, but not very long. Justice Gorsuch joined the court in April 2017. The National Right to Work Legal Defense Fund filed its petition in Janus in June of that year. The court granted the petition on its opening day order list at the start of the 2017 term. Who is Mark Janus, the named plaintiff in this case? He didn't start out as the plaintiff. The first plaintiff was actually the newly elected governor of the state of Illinois, Bruce Rauner, a Republican who had run for office on an anti-union platform, backed by millions of dollars in contributions from an Illinois businessman, Richard Uihlein, who also helps fund the Federalist Society, the National Right to Work Legal Defense Fund, and the Liberty Justice Center, a whole range of right-wing groups. With the state legislature controlled by Democrats, Governor Rauner could make no headway with legislation to abolish the agency shop, a step that states can take, and one that, in fact, more than half the states have taken through legislation. So he turned to the courts. But his lawsuit was dismissed because the district court declared the governor himself had no standing, and standing doctrine, as a matter of Article 3 of the U.S. Constitution, requires that a plaintiff in federal court has an actual injury. Governor Rauner's injury was ideological, but it wasn't actual. So Mark Janus, an Illinois state employee, was permitted to intervene as the new plaintiff, which was a pretty strange move because there actually, since the case had been dismissed, there was no longer an existing lawsuit in which to intervene. But no matter, this case, you might call it Friedrich's Redux, was soon on its way to the Supreme Court. The hurdle that Justice Alito and his 5-member majority had to overcome was, of course, stare decisis. And I'm not sure if people know stare decisis, but it's the rule of precedent. In our common law system, courts are obliged to respect precedents that were stare decisis means in Latin to stand for that which was already decided. So here was a decision, Abood, more than 4 decades old, that had been reaffirmed many times. So what to do? Justice Alito did something quite remarkable. He cited himself to show that any reliance interest that attached to Abood had long since been erased by his own dicta. Listen, here's what he said. Public employee unions have been on notice for years regarding this court's misgivings about Abood. In Knox, decided in 2012, this is Alito speaking, we described Abood as a First Amendment anomaly. 2 years later, in Harris, we were asked to overrule Abood, and while we found it unnecessary to take that step, we cataloged Abood's many weaknesses, unquote. He went on to describe the fate of the Friedrichs case, deriving from the tie vote the implication that the end of Abood was at hand. Quote, during this period of time, any public sector union seeking an agency fee provision in a collective bargaining agreement must have understood that the constitutionality of such a provision was uncertain, unquote. In her dissenting opinion, Justice Kagan called Justice Alito out, referring to the court's 6-year campaign to reverse Abood and observing that the majority had found, quote, no exceptional or special reason for doing so. It has overruled Abood because it wanted to. She continued, the majority has chosen the winners by turning the First Amendment into a sword and using it against workaday economic and regulatory policy the First Amendment was meant for better things, unquote. So I've delved at such length into the history of the Janus litigation to make clear the aggressive nature of the Supreme Court's attack on the status quo, a status quo anchored in democratic accountability. As I mentioned, states have been free from the beginning, either to adopt the agency fee system for their public employee unions or to reject it. Governor Rauner lacked the political power to accomplish his goal by legislation, so he enlisted a friendly Supreme Court. I might just add that Governor Rauner was turned out of office by the voters in November. His Democratic challenger is now the governor of Illinois. So the people were speaking about this. The disjunction between the court's decision last June and the public mood is worth noting. A Gallup poll conducted in early August 2018, about a month after the court's ruling, showed public support for unions at a 15-year high, 62%. School teachers in red as well as blue states have staged successful strikes for higher pay and better working conditions. To be sure, the fortunes of organized labor have ebbed and flowed throughout U.S. history, in the courts as well as in politics. Now we've entered an era when anti-union forces that can't prevail in politics are taking refuge in the courts. And that's a problem for the legitimacy of the courts, to be sure. But my point here is an even deeper one. What we're seeing in the Supreme Court's recent behavior is a threat to the foundations of civil society. Earlier in this talk, I asked you to keep in mind Justice Douglas's phrase, as quoted by Justice Stewart, the furtherance of a common cause. Stepping back from what Janus tells us about labor law or the First Amendment, I think its primary injury is to further constitutionalize the notion that we as a society are not, in fact, united in a common cause, that we can help ourselves to an opt-out of our choice, that we're not all in this together. There's been much talk about the rise of tribalism in the United States and elsewhere in the world. We retreat to our living rooms where the alternate visions of reality greet us from across the airwaves, cable connections, and the internet. It's increasingly hard to sustain the structures of civil society under these conditions. The Supreme Court once had an insight, as embodied by Abood and the cases that followed it until very recent years, that while we may disagree with one another, we're all playing by the same rules. And that's no longer true. When did it stop being true? It's not possible to pinpoint a moment, but it was certainly well before the 2016 election. The story of the Religious Freedom Restoration Act is instructive. Congress passed this law, which is known by its initials as RFRA, Religious Freedom Restoration Act, RFRA, to reject the Supreme Court's 1990 decision, a case called Employment Division against Smith. In Smith, the court, by a vote of 5-4 and with a majority opinion by Justice Scalia, held that the Free Exercise Clause does not offer a religious exemption from a law of general applicability. That case arose when the state of Oregon refused unemployment benefits to 2 members of the Native American Church who had been fired for using peyote, hallucinogenic drug, in their religious ritual. Oregon's position was that people who become unemployed through violating a criminal statute were not entitled to benefits. The plaintiffs claimed a right to benefits under the First Amendment's guarantee of free exercise of religion. Writing for the majority, Justice Scalia acknowledged that the men's claim was a sympathetic one, that Oregon might well have chosen to accommodate. As he noted, other states had accommodated in similar circumstances. However, he concluded, quote, "But to say that a non-discriminatory religious practice exemption is permitted, or even that is desirable, is not to say that it's constitutionally required, and that the appropriate occasions for its creation can be discerned by the courts." Justice Scalia went on, "It may fairly be said that leaving accommodation to the political process will place at a relative disadvantage those religious practices that are not widely engaged in. But that unavoidable consequence of democratic government must be preferred to a system in which each conscience is a law unto itself, or in which judges weigh the social importance of all laws against the centrality of all religious beliefs," unquote. That decision alarmed religious communities across the spectrum from the most liberal to the most orthodox. The result was the Religious Freedom Restoration Act, passed in 1993, Liberals were fully on board with this project of congressional triumphalism. The measure's chief sponsor in the House of Representatives, where it passed unanimously, was Representative Chuck Schumer, a leading liberal. In the Senate, where it was passed by 97-3, the chief sponsor was Senator Ted Kennedy, another leading liberal, and President Bill Clinton signed the bill into law. RFRA provides that, quote, government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, unquote, unless the government demonstrates that the policy or practice serves a compelling governmental interest by the least restrictive means. So what amounts to a substantial burden? By what test? How are courts to evaluate whether a challenged policy imposes the least possible burden on religious adherents? Is every religious claim equally weighty? What does the Establishment Clause have to say about this hyper-vigilant protection of free exercise? These questions went unanswered. In fact, they were scarcely raised. But Justice Scalia's warning came to pass. The political context in which RFRA was deployed changed dramatically during the following 2 decades. What its sponsors intended as a shield to protect minority religions became instead a sword in the hands of powerful forces representing the religious right and the Catholic Church. What we have now is indeed a statute that permits, one might say encourages, or maybe even requires, every conscience to be a law unto itself. The Supreme Court's Hobby Lobby decision from 2014 is the case in point. Hobby Lobby is a nationwide chain of hobby stores, craft stores, that employs thousands of people around the country. And the owner of this company claimed that under RFRA he was entitled to an exemption from the Affordable Care Act's requirement to include contraception coverage in the employee health plan. He raised a religious objection to certain forms of birth control that he deemed incorrectly to be abortifacients, to cause abortion. In an opinion by Justice Alito, the court held by a vote of 5-4 that the owner of this for-profit business was entitled to the same accommodation that the Obama administration was offering to religiously affiliated nonprofits. Churches themselves were exempt from the contraception mandate, and the Obama administration said that nonprofit organizations affiliated with churches could get a workaround. These organizations received the option of informing the federal government of their objection to contraception coverage, at which point the government would notify the organization's third-party insurers to pick up the cost directly. In other words, hands off, the religious organizations didn't have to touch the question, but the women would still get their coverage. The court held in the Hobby Lobby case by a vote of 5-4 that the existence of this accommodation for religious groups demonstrated that there was a least restrictive means within the meaning of RFRA to address a for-profit employer's religious concerns while still assuring coverage for those employees who did not share his objections. It's important to underscore exactly what the claim was here, both here and in the cases that followed. Obviously, nobody was forcing the Hobby Lobby owner, or in subsequent litigation, the Little Sisters of the Poor, which is an order of nuns whose chain of nursing homes both employs and serves non-adherents, to buy or use birth control for themselves. Rather, the claim was one of complicity in the sin of third parties, what my colleagues Douglas Nijame and Reva Siegel call a complicity-based conscience claim. There are 2 points to note about the nature and consequences of this type of conscience claim as it's evolved. One is the increasingly attenuated nature of these claims. Consider Kim Davis. This was a very famous case in the U.S. She was a Kentucky county clerk, and after the Supreme Court granted the right to same-sex marriage, she refused to issue marriage licenses to same-sex couples. Her job was to issue marriage licenses. But she said that under God's, quote, God's authority, she couldn't do that. She was prosecuted for that, actually. This was a straightforward complicity claim. She was saying, my signature on the license would enable your marriage. But the claims put forward in the months and years following Hobby Lobby were much more attenuated. Some employers asserted that simply submitting the opt-out form to the government would make them complicit. Others objected to a proposed workaround by which the government would act to assure contraception coverage even without any formal notice at all. On this logic, it's difficult to say where the chain of complicity would end. It's hard to see why an employer could not claim complicity in sin when issuing a paycheck that a female employee of childbearing age might predictably use to buy birth control products. The second point to note is the scant regard that the conscience claimants and the court pay to harms suffered by third parties from recognition of these complicity claims. While in the Hobby Lobby opinion, Justice Alito offered the view that the decision's effect on female employees seeking contraception coverage, quote, would be precisely zero under the accommodation that the court identified, that has proven not to be the case, as claimants have rejected one accommodation after another, each more generous. As Professors Nijem and Siegel point out, accommodation of such claims does not entail costs borne by society as a whole. Instead, accommodation has consequences for the third parties whose conduct is at issue. This became clear in the Masterpiece Cake Shop case last term, in which a same-sex couple left a bake shop empty-handed after the owner informed them that his religious objection to same-sex marriage made him unable to bake a cake to be used in celebration of their marriage. In other words, the owner of a public accommodation, legally bound under Colorado law not to discriminate on the basis of sexual orientation, claimed the conscience-driven right to be able to pick and choose his customers. The court decided that case in a way that sidestepped the main issue, but other cases are in the pipeline, and they will multiply in recognition that the Supreme Court's door is open. The Trump administration is now testing the boundaries of complicity-based conscience claims with a newly promulgated rule that permits employers to refuse to cover contraception on the basis not only of religious objections, but of sincerely held moral convictions as well. And that's the rule I mentioned at the beginning. Judge Beetlestone, granting an injunction, in the opinion that I began the talk with, marveled at this new rule's remarkable breadth and asked, quote, who determines whether the express moral reason is sincere or not, or for that matter, whether it falls within the bounds of morality, or is merely a preference choice? The administration, she observed, has conjured up a world where a government entity is empowered to impose its own version of morality on each of us, and that cannot be right, unquote. And that cannot be civil society as we have understood it. That case, too, will predictably reach the Supreme Court. It may seem a stretch to draw a line from Janus to wedding cakes to birth control, but I think all the cases I mentioned present a similar challenge to the Supreme Court and to us, to Americans. Will the Roberts Court further accelerate the tribalizing of America, or will this fractured court somehow find a way to invoke constitutional principles that help to hold us together, all passengers on the same boat in stormy seas? Quote, a democratic society cannot flourish if its citizens merely pursue their own narrow interests, the political philosopher Robert Audi wrote 20 years ago. And yet the atomistic First Amendment that the court appears to committed to delivering is enshrining pursuit of narrow personal interests as a constitutional right. Recall that Illinois, through its elected representatives, was perfectly free to abolish the agency fee system for its public sector unions, but the will of the people was otherwise. It was only in that realization that the governor turned to the courts to do his work for him. Civil society, by definition, exists outside the formal structures of government. Judith Shklar defines citizenship in part as having a sense of the social environment, an internalized part of a democratic order that relies on the self-direction and responsibility of its citizens rather than on their mere obedience. But neither does civil society exist apart from government, which has the power through law to regulate the structures that sustain it. The Supreme Court, in its role as Republican schoolmaster, a classic phrase, is an indispensable partner in the ongoing project of translating into operative law the values that vie for dominance at a given cultural moment. When the court moves from understanding the First Amendment as furthering a common cause to enlisting it as a tool that individuals can invoke to free themselves from the bonds of joint enterprise, something important has changed, and I would argue that something important has been lost. I'll conclude with a brief discussion of Supreme Court decisions that deal directly with citizenship. and that are disturbing in a different but related way. Decisions dealing with voting rights, the right to vote. These cases can be said to represent the other side of the same coin, not the individual right to opt out of citizenship, but rather a claim to inclusion, to a right that ought to be taken for granted at this stage in the history of our democracy, but that is under sustained attack. The right to vote has an important, indeed an all-embracing symbolic as well as practical dimension. This is not the occasion to explore in depth the controversy over Republican efforts to raise the barriers to access to the polls through, for example, requiring very precise forms of identification that elderly people, poor people, members of ethnic minorities are less likely to have or are less likely to be able to obtain easily. The Supreme Court dealt in an unfortunately superficial manner with the voter ID question more than a decade ago when it rejected a facial challenge to one of the earliest such efforts in a case from Indiana. The later 5-4 decision, a case called Shelby County against Holder, which disabled a major part of the Voting Rights Act, invites a deeper explanation than I can give it here, but suffice to say it was an act of extreme judicial aggression. In 2013, the Republican-led North Carolina legislature enacted one of the most comprehensive of the newly popular vote suppression statutes. The Fourth Circuit declared that law unconstitutional. Judge Diana Motz, writing for the court, that the law had been passed with discriminatory intent and reflected what she said was an effort to, quote, target African Americans with almost surgical precision, unquote. The Supreme Court denied the state's petition for certiorari, petition for review. In a separate statement respecting the denial of certiorari, Chief Justice Roberts spoke with evident regret about why the court had deemed itself unable to grant the state's petition. Shortly after the state filed its petition, a new governor and attorney general, both Democrats, had taken office. The attorney general moved to dismiss the petition. The General Assembly, still Republican-controlled, objected and moved to intervene in order to defend the law and to appeal the Fourth Circuit decision. The question of who had authority to speak for the state was looming without a readily apparent answer. So this is what the Chief Justice concluded in describing the ongoing confusion. Quote, given the blizzard of filings over who is and who is not authorized to seek review in this court under North Carolina law, it's important to recall our frequent admonition that the denial of a writ of certiorari, denial of review, imports no expression of opinion upon the merits of the case, unquote. The Chief Justice's statement was both gratuitous and revealing. He was saying unmistakably, I wish we could have gotten our hands on this case, but the political mess in the state makes that impossible. By no means, however, should anyone suppose that we approve of the Fourth Circuit's invalidation of this law. At the beginning of the year, Democrats in the House of Representatives introduced a bill they called a For the People Act of 2019, designed to increase the country's notoriously low voter participation by, among other measures, permitting same-day registration and making Election Day a federal holiday so that people don't have to go to work, they can go to vote. Senator Mitch McConnell, Republican of Kentucky, the Senate Majority Leader, took to the Senate floor to denounce the bill. He called it a power grab. Making it easier to vote is a power grab? That's the point to which the culture wars have brought us? Will the Supreme Court permit itself to be enlisted as a combatant in the cause of protecting voter rights or of enabling voter suppression? In the answer to that question and to the other questions I've raised here lies the future not only of civil society but of democracy itself. Thank you very much.
Thank you so much, Linda, for these disturbing and stimulating thoughts. So now we are open for questions. Who is going to start?
I think, is there a microphone for questions? Or?
Yeah, that actually. Please tell your name and then.
Sono Sista.
Thank you so much, Professor, for coming here today. It's really a unique opportunity to have you here in our law school. So my name is Leonardo. I'm a student here at the law school at the Law School University of São Paulo. And my question is, one can say that the main problem about the political activeness of the Supreme Court is that its political inclination from progressive to conservative or conservative to progressive eventually changes as time goes by. And besides that, it can be said that the Supreme Court ideological majority changes alongside with society sentiments and its political views. And in this way, if we have a conservative majority in civil society, therefore, we would likely have eventually a Supreme Court that has a conservative majority. And my question is, do you think the American society common political sense, or as to say the American common cause changed, or the Supreme Court understandings on all these matters are simply changing out of the judge's consciousness? And
So in other words,
but summing up, like the ideological political turning point on the Supreme Court decisions came from civil society or out of the Supreme Court's world?
Yeah, I mean that's a deep question, and in my view, the answer is the Supreme Court has been captured by a minority segment of American society, and I think we see this across a variety of issues. For instance, there's now finally a growing concern in the country with guns. And for the first time in many, many years, there's an effort in many states through legislation to have more regulation of guns, more gun control. And the Supreme Court has chosen this moment to get back into that question and take up a challenge to a very minor gun control regulation in New York. So we have society really almost finally coming together in the wake of these horrible, I'm sure you've read about these horrible shootings in the schools, to say we have to do something over here. The Supreme Court said, no, actually now is the time to kind of make the right to own a gun stronger than it is already. So I think we see the court not reflecting the broad currents in society, and it's really it's a dangerous thing for the court as an institution, and for the rest of us, I think.
What's your guess on the Supreme Court related to gun control?
I think there are 5 justices now on the Supreme Court. It's been 11 years, 10 or 11 years since the Supreme Court first granted the individual right to own a gun. And they had many cases since then. They haven't taken them because I think Justice Kennedy was on the court and the conservatives weren't sure they could count to a majority. And now he retired. And it's no coincidence that, within a few months of his retiring, they took up this new case. And it's a bad business.
Hi, Linda. I'm Juliana. I'm very thankful for your lecture. I have 2 questions. The first one is relating a little bit what you said yesterday about identity and culture and what you mentioned in your text today about tribalism. I, for one, am very uneasy with the arguments of those that blame identity politics for the rise of tribalism, and a list of those that put a spotlight on women's movement, LGBTQ, and black movement when doing so. So I wanted to know, how do you stand on this matter? If you think the identity politics is the main villain of tribalism, or if you think it's a consequence of it, and if you do think identity politics is at blame, if there's a way of making it without furthering this cultural war and fragmentation in civil society. And a second question that is related to Leonardo is, since the court seems to be hijacked by these group segments I wanted to know if you still think other segments, progressive segments, see the court as a fair arena to further their own interests, or if they're turning to other institutions and other measures to do so. Thank you.
Yeah, so those are also big questions. And obviously there is a tension between the kind of self-actualization of identity politics and we don't want to strip people of their identities as women, as racial minorities, as LGBT. But on the other hand, I think what's happening now is to enable people to say, as the baker in Colorado, well, I know there's a law that requires me to serve you equally, but I choose not to do that because my God tells me that if I bake you a cake, I will be complicit in your sexual sin. So that's where you could say, well, maybe the couple just should have gone down the street and found a baker who would bake for them and not make such a big deal of it. But, they thought this was a moment when, why should we have to take this? There's Colorado, not every state has protection for LGBT people in the marketplace. But Colorado, the voters of Colorado chose to protect. And so this couple said, we're going to assert our rights. And I think there always is that kind of tension that, society navigates more or less. Each situation raises it in a different way. But when you have judges coming in saying, okay, you don't have to play by these rules, you don't have to play by these rules, it just makes it very difficult to have interaction across these lines of the differences that we all have, that we all have to respect to some degree. I forget the second part of your question.
The second one is if other segments of society, the progressive ones, still see the court as a fair arena and an ally to further their interests, or if they are turning to other measures.
Yeah, so the question is, what are progressives supposed to do now? So this is being much debated right now in the U.S. There is an effort on the progressive side to talk about, maybe we have to change the court. Maybe we have to, because Trump got his two. When we get back in power, because they'll still be there, we have life tenure, so the Trump judges will be there for the next 30 or 40 years. We should expand the court, go from 9 to 11 or 13 and get our people in. It seems to me that's a bad way to go, because where does that stop? There's also more attention being paid to litigation in the states. So every state has its own constitution. Every state has its own court system. Some of these states are notably progressive, and some are not. Some will never be, but some could be more. And in an effort to bolster the meaning of equality or due process within the meaning of the state constitution. But progressives right now are in a hard place because because of life tenure, and Trump is filling up not only the Supreme Court, but he has appointed, as of today, 32 judges on the middle level Court of Appeals. That's a huge number. I just read this morning so we have 13 federal circuits. So the first circuit, the third circuit, which is in Philadelphia, has just flipped from majority Democratic to majority Republican because of 4 Trump appointees. That's the first of the circuits that have flipped, and they all will now. So it's a big problem.
Trump has been appointing because he was lucky that many basically retired.
Well, Trump was lucky because in the last several years of the Obama administration, when the Republicans held the Senate, they refused to confirm judges who Obama was appointing.
Not only in the Supreme Court, but
Oh, yeah.
okay.
Yeah, the Supreme Court was just the tip of a much bigger iceberg, and most law is made in the lower courts. The Supreme Court only decides about 65 cases a year. 65 cases a year. And all the other cases, thousands of other cases, are in the lower courts, and Trump is quickly getting control of those courts.
Hello, my name is Alexandre. My question is, I was watching an event last month, and there was a huge line on this event to take a picture with our Justice Faquin, like a celebrity. And also last night I was having lunch, and people next to me were talking about how this justice should vote on this case. They were talking like they really know our justice. And here in Brazil, we also have all the judgments live on TV, on the internet as well. My question is, what's your opinion about this high exposure of our justice and our Supreme Court to the public? Is it dangerous? Is it good? How do you see this high exposure and transparency of our Supreme Court? And my second question, really fast, how does it work in the U.S.? Is there some pressure for more transparency in the Supreme Court?
Yeah, so the two questions are really sort of combined. Yeah. So, I don't think there's anything wrong with the justices being a little bit more public, but it depends on what they're doing in public. So I think it would be in the U.S., it would be very shocking for justices to be expressing their opinions in public. So, for instance, some years ago, there was a case at the Supreme Court. It was a religious exercise challenge to, in our Pledge of Allegiance, I pledge allegiance to one nation under God, right? So there was an atheist father who said, my daughter should not have to pledge under God. I'm not raising her to believe in God, so that's a violation of my, my non-religious belief. And he brought a lawsuit, and he won in the lower court, and it was on his way up to the Supreme Court. Justice Scalia was giving a speech, and in the course of the speech, he said, that was a really stupid opinion. That's a stupid lawsuit. So the guy, the plaintiff, filed a motion for Justice Scalia to have to recuse himself and not sit on the case. And he had to grant the motion, and so Justice Scalia couldn't sit on the case. So we have a very strong norm that judges do not speak about the law. They can go around, they can talk about civic virtue, they can talk about, the pay for judges, the budget for the courts. Justice Ruth Bader Ginsburg, the notorious RBG, people have, little girls go around for Halloween wearing costumes to look like her, and people get tattoos. So, it's a little strange, but it doesn't really, affect the kind of legitimacy of the court because, actually, she gets a little carried away, so she has misspoken. When Trump was running in 2016, she said, if he gets, I'm laughing because it was so unusual, if he gets elected, I will have to move to New Zealand, she said. This was a scandal that she would say this publicly. And, then she had to apologize publicly. She said, I shouldn't have said that. I'm sorry I said that. Of course, we know she still believes it. On the other hand, she's still in Washington. She's not in New Zealand. So, it's a tricky issue, but I think so. You asked about more transparency. So we do not have television in our Supreme Court. They have it in other courts. And there's been talk about that, and the court doesn't want it. They don't want it for some good reasons, I think, actually. Because, of course, it's one thing if there would just be a cable network that would just show the whole argument, like maybe yours does. But you would have the networks that would pick off little pieces of it to make the lawyers or the justices look foolish. For instance, the court does record the audio, and they do put that out publicly. So, in the argument on Obamacare, big argument on Obamacare, the Solicitor General, the Obama official who was arguing to save the law, he got up to talk and he took a sip of water and he kind of choked. It went down the wrong way, and he was before he could start talking. The Republican National Committee put out a radio ad. They had the audio of him choking, and they said, even President Obama's top lawyer had to choke at the idea of defending Obamacare. Okay? And this was all over the radio. Now, if you were a Supreme Court justice and you heard that, you'd say, television? I don't think so. So, they do put out the audio. They put out the transcript of the argument the same day. They put out the decisions within a minute. So it's supremecourt.gov, supremecourt.gov. You can go on the website, and there's quite a lot. All the briefs are there. There's a lot there. The only thing they don't have is television.
Linda, do you mind if we collect 2 questions or something? No, there are many.
Yeah, sure.
Yeah. So, Danielle first, then.
Here's
Oh,
the
microphone. Oh, sorry. You.
He was in line as well.
I'm sorry. I'm my mistake. Please, you can. Yeah. So, please. Yes.
I actually have 2 questions. I'll try to be quick. First one is with the now increasing amount of progressive members of parliament in the United States, do you think there's a chance of increased litigation between Congress and the Supreme Court?
And the second question?
The second question is a bit unrelated, so I'll wait a bit.
So I'm not sure what you mean, litigation between Congress and the Supreme Court.
Litigation, not in the judicial sense, litigation in the sense of disagreement and the confrontation. Yeah. Confrontation between Congress
theoretically,
and the Supreme
yes, but our Congress is now divided, so the Democrats took the House, but the Republicans still have the Senate. So what that means is there really won't be progressive legislation. So theoretically, if the Democrats can get back the Senate in 2020, again, if the Democrats take over the government in 2020, the Senate and the White House, yes, there could be a lot of progressive legislation, and it would be challenged, and the Supreme Court, just like the Supreme Court in the days of the New Deal under Franklin Roosevelt, which was a big crisis for the country, could start striking these down. Yes, definitely.
The other one is, do you see a danger of these ideas of personal objections to legislation and to, rules of conduct being transplanted into Brazil? Especially since here we've already seen the appearance of several other ideas and situations similar to the United States, from people who deny climate change to people who deny even the theory of evolution, and the extreme rise of political and religious right-wing conservatism.
Well, all I could say, and I really can't speak to Brazil because it would be very presumptuous of me, I don't know enough, but all I can say is that we are living in a globalizing world, and ideas seem to be spreading from one country to another in politics very rapidly. Just look at Europe. So I think it's no longer possible to keep ideas, and Trump's trying to build a wall, right? But he can't build a wall against ideas. And so, yes, ideas do spread.
Linda, thank you very much again for your very thoughtful talk. I just want to follow up on one of the previous questions about the reaction of the progressive side to this conservative turn in the U.S. Supreme Court. So one response could be, let's be more aggressive in fighting nominations, or let's win elections and we can put our people in the Supreme Court or in the judiciary. But has the progressive side ever considered the possibility of actually making the Supreme Court weaker, or defending weaker forms of judicial review? So instead of trying to put our people there, so let's limit the power of the Supreme Court, of the judiciary in general, and give the power back to Congress, to politics.
Do you mean through legislation that would strip the court of jurisdiction over certain things? Yes, I mean, there is that kind of talk, and there was that kind of talk on the other side of the street during the Reagan years when the court was getting more conservative, but not like it is today. The conservatives wanted to strip the court of jurisdiction over prayer in schools and busing for racial integration and this kind of thing. It's within the power of Congress to do that if there was a majority, and a majority that could override a veto by the president. I think that's a dangerous way to go. Another question that confronts the progressive side is, do you want to appeal every case? Do you want to, do you want to serve up every time we lose in the lower courts, do you want to bring the appeal to give the Supreme Court the vehicle that maybe it's looking for to turn one regional loss into a national rule? That's something that confronts, certainly in the abortion area, it confronts the abortion rights side with every case. There was a case decided yesterday where they have to decide what to do. So strategizing on the progressive side is a real challenge right now, but it's going on. People are looking for any good ideas.
Tá bom, então. Túlio, depois eu volto para Two questions then. Okay. Túlio.
Okay. Thank you, Professor Linda, for your lecture. My question has to do with the process that you mentioned by which the authority of Abud was eroded by the court. And one of the phrase that you use is that no precedent is safe. What I'd like to ask, when do precedents are safe, if they were someday? Because when you are reconstructing the story, you mentioned that some decisions were necessary to gradually overrule the precedent. The fact that not in one decision the Abud was overruled doesn't mean that the story decides is working or the precedents are safe. And what would mean the special reasons or specific reasons that I think Justice Kagan requires for overruling the judicial precedents? Thank you. I think.
Okay.
Yeah.
Hi, thank you again, Professor, for your presentation. And you mentioned, I think, was Justice Kagan's critique of the First Amendment being weaponized in that labor and union-related case. And there has been a lot of debate about the First Amendment being a broadened application to economic and corporate cases. So I was thinking if you maybe could develop on that, in your views, about the Supreme Court's jurisprudence and the First Amendment application to not speech cases itself, but also to economic deregulation claims? And also, one quick question is that going back to the Colorado bakers, if you think it should make a difference if the cake's like a more general cake open to the public for someone to just pick and choose, or if a more craft-made artistic cake that could be related to, let's say, a painting by commission or something like that.
Right. Okay, so first I'll take the stare decisis. So that's also a big issue. So obviously, well, the kind of boilerplate phrase that comes from an opinion by Chief Justice Rehnquist from the 90s, stare decisis is not an inexorable command. Okay? So what does that mean? It's not an inexorable command. It means it doesn't always govern. So when does it not govern? And the court has worked out a kind of a formula for when stare decisis can be overcome. So it would be a case that was closely divided. Well, Abood was 9-0, but a case that was closely divided. A case that hasn't had generative force, that hasn't led to anything else. A case that has remained very controversial. A case in which there's no economic reliance, so it really doesn't matter that much. So you can set those up, and you know, Abood was a unanimous decision that's been reaffirmed. It's been narrowed over the years, but basically reaffirmed for 40 years, in which there was a great deal of reliance, because you know, unions counted on the dues revenue through the agency shop. So what Alito managed to do in this series of decisions was to delegitimize the precedent. You know, criticize it in the first case, criticize it more in the second case and the third case, so that he could then quote himself as saying, nobody should be relying on this. Can't you read? Can't you read what I've been saying? What we, the Supreme Court, have been saying for you know, for these last 6 years, and you know, wake up and smell the coffee. So it was a, you know, kind of a trick, and you can very much see the same thing going on with abortion right now. And of course, that's what everybody's concerned about. You know, every little case, yes, Roe against Wade, as exemplified by the Casey decision in 1992, still on the books, but it doesn't cover this, it doesn't cover that, it doesn't cover that. So, you know, there could come a time in the not too distant future when you say, well, we've been telling you for years that the right to abortion was, you know, very problematic, and, you know, all we're doing is just kind of pushing it over the edge with a little. So, I guess you don't have a stare decisis kind of regime here, but it's very tricky and very fascinating. Okay, so the question was about the First Amendment, right? So it's really quite remarkable that, you know, it's now sort of common acceptance that the First Amendment has become a tool of deregulation. And so, you know, Americans were kind of raised, certainly, you know, anybody at my age raised to think the First Amendment is great. You know, anytime you hear the words First Amendment, you want to stand up and salute, because it's free speech, it's, you know, self-actualization, it's, you know, the court has ruled that First Amendment gives you the right to have, you know, nude dancing and pornography and, you know, everything. So how did this happen? So, so a doctrine came up in the 1970s, commercial speech, and it's again one of these things. It's like the Religious Freedom Restoration Act. It initially was something embraced by liberals. I mean, the first commercial speech case was a challenge to a law that forbid advertising by pharmacies and drugstores, and it was it was a law that was meant to protect the little drugstores from the big chains, because the little drugstores couldn't afford to advertise, the big chains wanted to advertise. And so this law was invalidated in the 1970s and established the notion that even, corporations have speech rights. And it just kind of grew from there into what we have now, where a tobacco company can say, even though I'm a regulated industry, you can't tell me that I have to warn people about the consequences of smoking by putting these disgusting pictures on the packet. Or in the Sorrell case that I mentioned, where Vermont was trying to keep the pharmaceutical companies from basically making it harder for doctors to prescribe the cheaper generic drugs. They were able to get the prescription information from the druggist, which doctors are prescribing which drugs, and they could go to those doctors and say, our drug is better. And of course, that's coerced speech. You can't make the pharmacy company information available to the public. So the notion of what's expression, what's coercion, is all tied up with this, and it's not going to stop anytime soon.
So, Virgílio?
Just cut the line. I have lots of questions, but I will ask only two. And if we have time, I would like to comment later about voter registration in Brazil. And if you say, well, same-day registration in Brazil, no way at all, You have to, but this is another subject. I would like to ask a question about on conscientious objection. Well, you have the official that refused to perform same-sex marriage. You have the doctor who refused to perform an abortion. You have the young man that refused to join the army. And you have the baker that refused to bake the cake. Is there any criteria to distinguish legitimate conscientious objection or not? Or should we simply, for the sake of solidarity and for the civil society, simply get away from this notion conscientious objection is too individualistic, we don't want this anymore? That's the first question. And the second question is related to the form of appointment to the Supreme Court. It's somehow related to the first question, whether the court majority reflects the majority in society. And as you know, it's in Brazil as well in the U.S. In the U.S. it's much worse in this sense. The majority of the court is built by chance. So one president has the chance to appoint 3 or 4 justices, and if he or she is wise, he will appoint someone who is 40 years old. And the same as in Brazil. For instance, President Cardoso was 8 years in office and could appoint only 3 justices. Lula was also 8 years in office and could appoint, I think, 7 or 8. Mm-hmm. And is there any debate on term for the Supreme Court? And more important than term, I think it's the majority for appointment. Simple majority is too low. 2/3 may be bring more equilibrium to the courts. If there is any discussion on this subject, thank you.
So, in your first question, should we just get rid of conscientious objection, and what's the criterion? I think an important criterion is the notion of third-party harm. So, we do have conscientious objection from the military by statute, and you have to meet, certain criteria, and then we don't have a draft right now, but back in the days of the Vietnam War, this was very, and of course you can say, well, if you don't go, then maybe I have to go. But it's a very generalized, really society-wide kind of notion. It's not, you're not trading your life for mine, and so it's something that society through legislation has decided is worthy of respect, and I don't think anybody's, challenged it one way or the other, and I think that's, quite different from. I guess I didn't get to your second question about the baker as the artist. When somebody gets a license to open a business, you can't just open a business. You get a license and you abide by certain regulations, and there's certain laws that govern. You have to pay your employees at least a certain amount of money, and you have to, if you're dealing with food, you have to have the food inspector come in and all these things. You undertake certain obligations, and one of them is you have an open door, and whoever walks in and wants what you do for a living is available to them. And so, say, for instance, an interracial couple came into that store, a black woman and a white man, and, hi, we're getting married, and we'd like you to make us a wedding cake to celebrate this. Well, I don't believe in interracial marriage, and I can't bake for you. Nobody in the country today would put up with that. That would be totally off the table. So, what's the, and back in the day, interracial marriage in the U.S. was not made a constitutional right until around 1960, right? And the opposition to it was, my religion, God tells me that every race should stay to itself and we shouldn't have this. So the baker could say, well, my religion says I can't serve you. Once the state of Colorado, by legislation, adopted a law putting LGBT people in the same class as no discrimination on the basis of race or religion, it seems to me there's nothing for the baker to say other than that, I guess I better not be in business. I'll just bake cakes out of my kitchen. And, that's because there's direct third-party harm there. So that's kind of my answer to that. What about fixing membership on the U.S. Supreme Court? There is big debates going on now. And the question is, lots of good ideas floating around. The question is how any of them would ever get accomplished. So life tenure is hardwired into the Constitution. Now, that can be changed by constitutional amendment. It's really hard to have a constitutional amendment. There's only been, I think, 27 or something in the whole history of the country because it requires a 2/3 vote of each house of Congress and then ratification by 3/4 of the state legislatures. That's really hard. So it's not too likely. One idea is if every justice had an 18-year term, that would mean that every president in a 4-year term would automatically get 2 appointments. And that would take the randomness that you mentioned with the Brazilian president. So President Jimmy Carter had no appointments. And he was followed by President Reagan, who had 4. Okay? It's random. Makes every appointment a big, big thing. There's a theory that it could be done by legislation. If once somebody's appointed to the Supreme Court, they do have life tenure as a judge, but their active service on the court is only 18 years, and then they become a senior judge, and we have this on the lower courts. People, by their own choice, once they turn age 70 and they have at least X number of years of service, they become senior judges. They get their same salary. They keep their same chambers. They can work like half-time if they choose. So, that's an idea. Having a supermajority requirement, which we had until the Republicans in 2016 got rid of it. It was by rule, not by law, but by rule, you needed 60 votes out of the 100. They got rid of that, and so Gorsuch and Kavanaugh were approved by, I think, 51 votes each. That would not have happened if we still had. So I actually think the supermajority is a very good idea. I know, for instance, in Germany they have, and that that forces the nomination process away from the extremes.
It doesn't matter who is the prime minister.
Yeah. So I think that's another good idea. Again, you need political will to make it happen.
So I'll collect two questions now. You and then Livia. He's asking whether these particular change could be done by legislation. Yes. I think.
Yes, or the supermajority could just be done by rule in the Senate. It doesn't have to even be
legislative resolution.
Yeah, and the right. I mean, for legislation, so legislation in the Congress is subject to a filibuster, which means that it's again by rule. You need 60 votes to bring something to a vote. So there'd have to be a considerable majority thinking it's time to make these changes, and whether that could happen.
You don't need a constitutional amendment for sure.
You would not need a constitutional amendment.
Yeah. So yeah.
Thank you for coming, Linda. It was a pleasure getting your thoughts on many of these issues. My name is André. My question is a quick question. It builds up on Professor Virgílio question, and it's about the composition of the court. And we know Justice Ginsburg is fighting an illness and could be off the court soon. And a piece by Jeffrey Tobin also speculates on Justice Clarence Thomas. One is known as a progressive and the other known as a conservative. And the speculation from this analyst, Tobin, which is also very respected, is that both are trying to delay until after the 2020 elections so that Trump doesn't get to pick two more justices. So my question is, how do you stand on this? Do you think this is reasonable? And what's the court going to look like after this?
Can I take a second question?
Okay.
Yeah, Livia? There.
Hi, Professor Linda. Thank you again. My question is, I'm going to simplify a little bit, but it's with the rise of the right wing of the court, let's say, and I wanted to know, I was wondering if the left wing of the court has made some different movements or internal arrangements or coalitions or even strategies to convince the middle judges, if there are still some middle judges, for example.
Okay, so I think what Jeffrey Tobin wrote about Clarence Thomas, which actually I don't think is true, but the idea would be that Thomas would retire while Trump is president so that Trump could appoint somebody ideologically the same as Thomas but younger, because Thomas is in his late 60s now. So if you could replace Thomas with a 40-year-old Thomas, that would be. So this all comes under the heading of strategic retirement, and it's an artifact of life tenure. Obviously, if they had 18-year terms, this wouldn't be happening. So it's another problem of life tenure. And definitely Justice Ginsburg is trying to hang on, and she was subject to a lot of criticism for not retiring while Obama was president. And I thought that was unfair, actually. She's not young, but some of the progressive guys are not young. Justice Breyer is almost her age, and nobody was saying, Justice Breyer, you should retire. You take a bullet for the cause. So it made me quite uncomfortable. Well, eventually all 9 of them will be gone, but we may not be here to see it. So in Livia's question, so that's a really interesting question. What are the progressives on the court doing? And I'm trying to watch this, and I want to write about it myself, but there actually seems to be a division within the 4 progressives. So that's Justice Sotomayor and Justice Ginsburg seem to be call them out, dissent. Justice Kagan and Justice Breyer seem to be, we got to try to work with them. And Justice Kagan is very strategic. She's very smart. She was dean of the Harvard Law School before she became a justice. She got high marks at Harvard for bringing together liberal and conservative professors who, before she got there, nobody was even speaking to each other. Harvard Law School was in a big mess. They had so many fights among the professors they couldn't even hire people because nobody could agree. And she came in, everybody started loving everybody. So she has a lot of people skills. And the only problem is she doesn't have much raw material to work with. So the only one that we think might be sort of in the middle is Chief Justice Roberts. And that's a pretty thin read because he's very conservative. I had thought initially maybe Kavanaugh, not in these early months the way Kavanaugh's behaving. So I think she's trying. I think she succeeded a couple weeks ago in a case that I want to write about, but I sort of had too many other things to write about. A death penalty case where Roberts had, the court a couple years ago, it was a Ginsburg opinion, had struck down this individual's death penalty. Roberts dissented at that time. The case went back to the lower court. The lower court reinstated the death penalty. It came back up. Kagan got the opinion. She invalidated again, very narrowly, but enough to get this guy off death row. And she got Roberts to come along. That I think, I mean, nobody paid attention to this, but I think it was very important sign, so I'm trying to understand what's happening.
So we have 5 minutes left, and we have 3 persons on the list. Is there someone here? Oh, sorry. I didn't see you. I looked many times this side. So let's start by you. Who holds the microphone? Yeah, I know Arthur, you, and I forgot your name, Otávio, and then we come back. So let's do 2 and 2. And after 5 or 7 minutes, we can finish. No, let's just leave it. Yeah.
Hello. Thank you for your lesson, Professor. My name's Felipe, and the question I wanted to ask you is: you spoke of a case that a lower court invalidated a voter registration act for some state, and that the court decided that the law was made with the intent to target minorities.
Yes.
And there was also, they took in consideration the intent of the legislator. The same thing was thought to happen in the travel ban case. They said that it was made with the intent to target these people. Is it usual in American courts, historically, to take in consideration the intent of the legislator or of the government? And should it be? Wouldn't that also create a case of a slippery slope that could, turn against the civil society or whoever defends that? Thank you.
Arthur?
Thank you again, Professor Greenhouse. You said earlier, actually, in your lecture, thank you for that, that no precedent is safe. And going back to the First Amendment, there was a statement regarding denial of certiorari by Justice Thomas a few weeks back, where he criticized New York Times v. Sullivan. And I want to get your perspective on whether Sullivan might be up for grabs as well, in light of the President Trump's criticism of defamation law, and perhaps also of falling support for the First Amendment basis, which protects even hate speech. And if I could get a second question, I heard you were at that podcast, was it First Mondays, and you were in 2017, and you were discussing Chief Justice Roberts and his role, and how you thought he might be instrumental in securing legitimacy for the court, how his role as Chief Justice might prove decisive as someone who takes a step back from conservatism and thinks of the court on an institutional perspective. And on your lecture today, I had this sentiment that you feel less optimistic about that. Would that be a fair assessment of your remarks earlier?
Okay, that's a quick answer, and yes, I am less optimistic. So, and I'll work backwards. So Clarence Thomas did say the other day that he thinks New York Times against Sullivan, which is the landmark First Amendment case that constitutionalized the law of libel and protected media against libel suits for libeling public figures and certain private figures. So Thomas is kind of working his way through all the major precedents of the Supreme Court and announcing that they should all be overturned. He does not actually have company on this, and that is that's not going to happen. I don't know what is going to happen in a whole bunch of things, but that's not going to happen. Okay, remind me, just give me one key word so I remember. Oh,
legislative intent.
Intent. Okay, so intent is a very tricky notion. So the Supreme Court back in the 70s had an important decision called Washington against Davis that said that in the area of equal protection, interpreting the 14th Amendment, equal protection, to find a violation of equal protection, you have to find intent. It can't just be an accidental outcome of a government policy. It has to be intent. So there we are. So in order for the judge who wrote in the North Carolina voter suppression case to find that what happened was unconstitutional, she had to find intent. This is a result of the intent of the legislature to undermine the ability of minorities in the state to get the requisite ID and vote. So, this was in the Trump travel ban case. This was raised as an issue, but of course the court upheld the travel ban, and in a kind of muddied opinion that they sort of acknowledged things. The president has not spoken very well about this, but he is the president, and we defer to his judgment that, national security, blah, blah, blah. So it was not a very satisfactory opinion. So is intent a slippery slope? It certainly empowered, the court helped itself to a bunch of power to be able to be the one to discern intent. And this whole issue is very much in play right now. It's for more than I would have time to go into, but it's you identify a question that's sort of at the boundary of what people are working on right now.
Okay, Otávio. And Sabato.
Thank you, Professor, for your lecture. I apologize, I was a little bit late, so I don't know if I already addressed this matter. But at the same time, I didn't want to miss the opportunity to ask you this question. You mentioned a quote that said that despite our disagreements, we are all playing by the same rule. And that made me think a little bit about hate speech laws or group libel laws. And how do you say, I know that's not the same thing as like using the First Amendment against against regulations in labor issues, but how do you feel about this matter? Would it be hate speech we would be playing in the rules, democratic rules, or not? How do you say about that?
So I guess I don't see those as kind of in the same part of the forest. So, what the court has a new case where they're asked to sort of define the boundary between hate speech and what's called a true threat. It's one thing to sort of spout off, but on the other hand, what can be suppressed as an actual threat. And I personally, I don't see the hate speech issue as a huge problem in constitutional terms. I think it's a problem in society because we have people marching around saying hateful things. But I guess I haven't thought of that as something that's really kind of front and center on the court's docket. It's really more for politics, I think. And, unfortunately, we have a president that seems to think that, there's good people on both sides, as he said about what happened in Charlottesville. So that's kind of enabling bad forces in our country. That's a political problem.
So we have one last question. Sure.
Hello, Professor. Very thankful for your lecture today. And I would like to know what is your opinion about the last nomination for the Supreme Court, Brett Kavanaugh, and what do you expect for the next election in 2020 about almost hardball constitutional hardball of Democrats if they win the election? What do you think about it?
Can you translate a bit for that?
So he wanted to know about your opinion on Justice Kavanaugh, the last nomination.
Justice Kavanaugh, okay.
Yeah, and then your guess on 2020, only that.
Yeah, I mean, the Kavanaugh thing was very sad, very, just nothing good came out of it. It was made me just very uneasy. I know him, I've known him for years. I was very surprised by what came out. I was very surprised by his behavior. But it was power politics. It was constitutional hardball. There we are, and we just have to hope that we know he's going to be there for a long time, and we have to hope that he has an eye to his place in history that transcends what came out in the confirmation process. What's going to happen in 2020? The court packing with so Democrats are saying, if we get the White House and we get the Senate, we may try this. We may try to expand the court. There's a lot of debate about whether that's a good idea. We do it when we're in power, then they'll do it the next time they're in power, and eventually we'll have 50 people in the court. I don't know. But, there's a number of very smart people that are thinking seriously about that.
Virgílio has a last question then.
Just about court packing, it's a bad idea everywhere in all times. But I would like to get back to very quick to the legislative intent and voter ID and voter registration. The first time I read about this a couple of years ago, that, how the voter registration or non-registration work in the U.S., I was shocked, really shocked. We are simply accustomed with how it works in Brazil. It's really strict rules, voter registration. Now you have biometric identification. It's my question is the requirements of voter registration as such doesn't target anyone. Of course, it may have negative effects on specific groups, and these groups support the Democrats in general, and that's why the Republicans like to introduce a voter requirement. But I would like to ask you how this is not going to change. So how is it possible to introduce, if we think that the absence of voter registration is cause of fraud in the elections, how can we change it? Because every attempt to change it will negatively affect those minorities. So are we, it's impossible to change it? Should we live with this forever?
Well, a couple of things. So voting requirements in the U.S. are state by state. There's not a national rule, right? There's really no such thing as in-person voter fraud. There are no cases of I'm showing up to vote and saying, hello, I'm Virgílio and I'm here to vote. It doesn't happen. And Trump set up a commission headed by the main guy, a guy named Chris Kobach, graduate of Yale Law School, very conservative guy, who's been putting out this idea of voter fraud, set up a big commission with a big budget. Show us all this voter fraud so we can have the ammunition to get this. And the commission, after a year, they hadn't come up with anything and nothing. And all the other commissioners quit, and the thing was shut down. There is fraud in elections. There was horrible fraud, came to light just a few weeks ago in North Carolina, invalidated a congressional election. Not people showing up saying they were somebody else, but an operative hired by the Republican candidate to go around to people who were submitting absentee ballots where you mail it in and saying, oh, I'll bring your ballot to the polls. You don't have to go. I'll collect it for you. And then he was making up what they had on the ballot. And it was a trial, and the candidate confessed, and the guy who was doing this is in prison. I mean, it's a big mess. There is fraud, but not the kind of fraud that these laws pretend to aim at. So, but I went to vote, in November. We had a big election. In Connecticut, we don't have the voter ID. You just get a little postcard in the mail. It says, here's your place to vote. Here's the time when it's open. And I brought that to the polls. And the poll worker said, I need your photo ID. I said, no, you don't. No. And she said, well, that's the law. I said, it is not. And they had to call over the supervisor. She said, well, she's right. It's not the law. But not too many people are going to fight back like that. But you're right. I mean, it's a shocking mess. It is a shocking mess. Now, one way to do it is when somebody registers. So there's two things. You register to vote, so you're on the list, and then you show up to vote. When people register to vote, they're given, we'll take your picture. Here's the card. Bring it to the polls. That's that. But they don't do that. So Texas, for instance, requires to get the voter ID, you need a birth certificate. They used to you could do it if you just had your ID card, if you were a college student, if you had your ID card from college. They said, no, that's not good anymore. You need your birth certificate. Well, I have my birth certificate in a drawer somewhere. Maybe you have yours. But, a lot of, minority people or poor people, they never got their birth certificate. It's somewhere, you could get it from the place where you were born. You'd have to send them a check for $25 or something, and they'd get it in a month. So there's no reason for that, and it's just a manipulation of the system. So that's a big problem.
Okay, so before we close, I just want to make two announcements. First is an advertisement. Linda Greenhouse has a wonderful book called Becoming Justice Blackman. And this book is many things. It is the story of the justice who wrote the majority opinion of nothing less than Roe versus Wade. It also is, a kind of judicial biography, working on the papers of that particular judge. And most of all is a great way to see how you can learn constitutional law and the internal workings of the court by looking closely at the life, intellectual life of an important judge. Secondly, we have the next dialogues in 2 weeks' time, right?
Yes, 25th of
25th,
March. Yeah.
And we have Professor Matthias Klatt talking about fundamental rights and
constitutional interpretation.
Yeah. So, Linda, it was excellent. We all want to express our thanks, and we hope we can keep engaging with such an important topic. And comparing Brazil and US, we mirror a lot what is happening there, and we make it worse sometimes.
Well, not necessarily.
Thank you.